North Carolina lawmakers should protect its citizens from eminent domain abuse. That is the conclusion of the Locke Foundation's Director of Legal Studies, Jon Guze. Jon, writing at jonlocke.org recently, points out that North Carolina is one of the few states that has not been successful in robustly protecting its citizens from having their homes taken and given to a developer. It's all part of this Kelo decision from a number of years ago. Jon joins us now with an update on what's happening across the country. Jon, welcome back to the program.
Thank you, Donna.
First of all, just briefly review for us the Kelo versus City of New London decision, that Supreme Court decision. Why are so many people concerned about that?
Well, it's really turned out to be one of the most unpopular decisions the Supreme Court has made, certainly in my lifetime. And the reason is pretty obvious. What happened in New London is this: the city invoked a state law and gave a private development corporation the power to take ordinary citizens' houses so that they could use the land to build what they called a high-end development that was going to involve apartments, offices, hotels, and so on. The city liked the idea. They thought they'd get more revenue, they'd get rid of a working-class neighborhood and have something upscale. But the people whose houses were going to be taken, one of them, a nice lady named Suzette Kelo, opposed this. She decided to stand up and fight, and she rallied her neighbors, and they did. They fought all the way to the U.S. Supreme Court, where, much to everybody's disappointment and in some cases like mine, shock, they lost. The Supreme Court said it's perfectly all right under the U.S. Constitution for a private developer to take land from one group of private citizens and give it to another private citizen for commercial development.
One would think that would not happen in a free country like the United States, but the homeowner would be compensated. But the point being that if a city official somewhere decides that, gee, you happen to have a house or a neighborhood on land that has become valuable for one reason or another, or we think that it would be better used for a shopping center, we can just take it from you?
Well, that's the law. At least that's the federal law. People thought that the Takings Clause of the Fifth Amendment forbade this sort of thing. Under the Takings Clause, it says that property may be taken for public use. And for a long time, everybody assumed public use meant something like a school, a federal building, a prison, a military base, a road, or possibly something that was by a public utility like a railroad or the telephone company to put up lines, but it had to be something that was open to the public, to all comers, not a private developer. This is the thing that seems so shocking.
Now, Jon, we know that some states have reacted to this and trying to do things that would protect their citizens from this. North Carolina, as you write at jonlocke.org, North Carolina, not one of those states that has yet been successful at doing this. Tell us what some other states have done.
Yeah, so what happened after Kelo is there was this public outcry all across the country, and one state after another passed laws under their own state laws to do something to prevent this from happening. There were two ways to go about this, and most states did something along both lines. You can add some provision to your own state's constitution that would put some teeth into a takings clause, and you can also write your own state's statutes regarding eminent domain in such a way to prevent these. Ideally, what these states have done is put provisions in that specifically forbid takings for commercial development. They state specifically that won't constitute a public use. Even states that haven't done that, though, have found other ways to put restrictions on to protect property rights. Interestingly enough, the region that's done the best job overall is ours in the Southeast, and the two states with the best eminent domain laws now, by I think all experts would agree, are Virginia and Florida. We're lagging way behind, and it would just be nice to see something done.
Jon, let's make sure that our listeners understand. So we're talking about Kelo being a United States Supreme Court decision. You're talking about states taking action in their own state constitutions. So which trumps which?
Well, the federal law trumps state law. So if it were the case that the Supreme Court had said, no, you can't transfer from one private party to another for commercial development, that violates the Fifth Amendment. If the Supreme Court had said that, then no developer in any state would be allowed to do it. But what the court said instead was, we're going to leave this to the states. they said, it's not for us, a federal court, to decide what constitutes a public purpose. They said public use, anything that serves a public purpose constitutes a public use. Commercial development by improving the tax base or whatever is a public purpose. Therefore, it passes muster. And they said, we're not even going to investigate. We're going to leave it up to the states to make these decisions for themselves. So, and in fact, the decision specifically says, now there's nothing we say here today prevents states from putting in more strict requirements and protections, and many states have done it, but North Carolina so far has not.
There have been efforts, though, in North Carolina by some to try to do this, but it has only been partially successful.
That's right. There's been repeated efforts. There's been a group of very diligent and dedicated members of the North Carolina House that have tried 7 times to, they have written bills that would add more protection of property rights under the state constitution and the state statute. 7 times these have passed in the House, either unanimously or almost unanimously, and 7 times they've gone to the Senate, but every single time they've died. It's happening right now. Just this session, the House passed another eminent domain reform bill, and now it's sitting in the Senate.
And as the point that you and I are talking, that has not moved from the Senate. The lead author of the Kelo decision is now a former Justice, John Paul Stevens. He's been talking about this decision recently.
That's right. He's recently published a sort of a memoir. It's not exactly an autobiography because it deals primarily just with his time on the court. He reviews many, many decisions, including, needless to say, Kelo, because that's one of the ones for which he's been most severely criticized.
What's he saying?
He's saying, I made the right call.
Oh, my gosh,
He has no regrets despite all the criticism. He still thinks that was the right way to go. And, given a certain attitude about the role of the Supreme Court, I guess that makes sense. We've had federal courts in general and the Supreme Court in particular be very deferential to both the Congress and to the state legislatures when it comes to economic matters. And as far as Stevens is concerned, that's how it ought to be.
John, this is a situation that Suzette Kelo faced, and she tried to fight back. Most people would say, gee, that sounds terrible, but that'll never happen to me.
Well, I think until the Kelo decision was handed down, most people just assumed it couldn't happen to them. They didn't realize that it was happening all over the country. Now, I will say this. We've been pretty lucky in North Carolina. Compared to many states, we haven't seen much of this kind of eminent domain abuse, and that's because our Supreme Court has interpreted our law of the land clause in a way that restricts eminent domain. But I think what the state houses wanted to do, and what I think ought to be done, is we don't want to rely on the courts, because we know from Kelo that if they want to, the courts can interpret the law in a way that allows this kind of abuse. It would be nice to see something in writing to make sure it couldn't happen here.